I'm going to call this open business 1. And my motion is I would like to make a motion requesting Mayor Sellers through Gus Andreason along with Howard & Howard as Corporation Counsel.
Can you make the motion?
I made the motion, yes, so I need a
As
support.
chairperson, though, can you make?
Yes.
Okay.
Okay, I have a motion by myself, supported by Councilman Remick. Is there any discussion? I have some discussion. My reasoning for this is when the council attempted to obtain information and documents from the mayor's administration during council's investigation of Howard & Howard, defended the mayor in response to council's investigation and did everything in their power to fight city council's investigation. Howard & Howard served 49 pages of objections and excuses not producing documents requested by city council. This was a direct violation of section 2.5 of the city charter, which states all books, papers, records, and accounts of any officer elected or appointed of any office, department of the city shall at all times be subject to audit, examination, or inspection by any member of council or by any person employed or designated by the city council. Howard & Howard should have been assisting the city council in its investigation. Instead, it did everything possible to prevent and hinder the council's investigation in all violation of the corporation council's duties under the city charter. My second reason is pursuant of section 5.11 of the city charter, and corporation council has legal duty to act as legal advisor to the mayor and the city council, and must give legal opinions concerning affairs of the city to the council and the mayor. Therefore, the city charter requires that the city's corporation council must represent both the mayor and the city council in all matters related to the city. But when the city council reported to the Michigan Attorney Commission that Howard & Howard had a conflict of interest when it defended and obstructed the city council's investigation of the mayor, Howard & Howard responded by lying to the Attorney Grievance Commission and stating there is no conflict of interest because Howard & Howard has never represented the city council on any matter. Howard & Howard further lied to the Attorney Grievance Commission by stating the city council has never been a client of Howard & Howard, and Howard & Howard has never given the city council legal advice on any matter. But this is exactly what the Taylor City Charter requires them to do. And my third reason is basically entering into a agreement with a vendor without council approval. These are my reasons for this. I think there's sometimes when you do business for a while, changes need to be made. I do believe this is one. That's the reason I made this motion. I do want to point out, I have nothing against Gus Andreason. I like Gus Andreason. I would call him a friend. But in my opinion, I think it's time for somebody else to maybe be the corporate counsel of the city council and the mayor. So is there any other discussion? Councilman Remick.
I have to totally agree with you on this for the simple reason I have been a victim of this several times asking for information. And that book that we go by, that charter, it's been violated against me. So therefore, we do need someone to step up and support this council. This council will make decisions that basically this council runs this city. The only problem is we have yet to put our foot down to show that we do. And court documents prove that we do. Thank you.
Mr. Chair, I have just a clarification on the motion. So the motion is calling for court.
The mayor has to
the council to use a different court counsel.
Well, we could do that technically, yeah, but that is one of our avenues. I'm requesting that the mayor bring forth another because he has to bring them forward for us to agree upon.
Okay.
However, we do have a list of lawyers that the city has agreed to use that we could use as our own legal advice if we decided to do that.
Okay.
But the mayor would be the one to bring somebody to us to vote in for a corporation council. Okay. Is there any other discussion? Okay, if not, all those in favor say yes.
Yes. Yes.
All opposed say no.
No.
Roll call, please.
Mr. Bzura.
Yes.
Mrs. Patz.
Yes.
Mr. Remick.
Yes.
Ms. Winton.
Yes.
Ms. Croft.
Yes.
Mr. Johnson.
No.
Mr. Woolley.
Yes. Motion carries. Okay, now I would like to open the floor to any council member or the mayor or anybody that would like to discuss something. Councilman Bzura?
I was just hoping we could follow up on GFL and service level and any potential changes that may be getting made to how we're reporting and tracking missed pickups through our call center.
Sure. Mr. Bach, could you come on down, please?
I realize that it probably takes time. I just wanted to hear if in fact changes were being made. One of the big concerns I expressed was the fact that in order for us to enact the liquidated damages portion of our contract, it actually requires, our current process requires a resident to file 2 complaints over the same missed pickup, and I think that's an unfair burden to put on residents. You complain, we should follow up on it until your problem is resolved. And to my knowledge, what we're still doing is closing those eye care cases when GFL acknowledges them instead of keeping them open until the garbage or compost is actually picked up. So I'd like to put the burden on GFL to fix their problems, not require residents to complain multiple times about the same issue.
Okay, is there a question in that?
Are we doing anything different, or are we going to let GFL continue to get away with murder?
Well, I don't get the complaints. I'm going to be clear with you right now. I don't receive them.
We've got the eye care app to do that.
They go through the call center. I don't even get any phone calls. I occasionally get an email through the website, which I forward to Brenda, who's keeping track of the complaints. Last month, the last invoice, we deducted $2,800 based on Brenda's paperwork that she puts on the Google Drive. Every month when I get an invoice, I look at that and I subtract the ones that we have to confirm. We have to confirm that he has not complied with the contract. I just can't find somebody that because of a misstop. He has to have an opportunity to correct that. It's in the contract. But this is a very difficult follow-up because they're spread out all over the city, and we would have to have someone physically drive to each one of those, which just is not practical.
Why don't we make them do that? If they don't confirm after we gave them notification, the contract simply says, if you don't resolve the matter by noon the next day, we're going to hit you with $100. So they either confirm that they did it, or
as far as I know, they are confirming it with the call center. Brenda's following up on those.
We were told that the case gets immediately closed on iCare when GFL is made aware of the miss, and if they don't go back and the resident doesn't file a second complaint, there's no way for you or anyone to know that you should be deducting $100 from their bill. Why would a resident have to complain twice? And why can't, under the terms and conditions of the existing contract, can't we require GFL to confirm that they fix their mistake?
I will check with Brenda, but that's what I thought the process was. That Brenda was following up with GFL to make sure that the first...
What council was told is that if the resident doesn't file a second complaint, there's no way for the city to know whether it got picked up or not, and therefore there's no way of charging them $100.
Well, I have, like I said, those go through the call center, so I'll have to follow up with Brenda this week and find out what the process is. But as far as I know,
Mr. Chairman, I don't believe that's accurate, Councilman. I don't believe that the burden is put on the resident to confirm via a second notification. I believe it is left open until it is confirmed that the pickup has occurred.
I mean, this is why I want to have the discussion, and I'm not blaming Brenda, I'm not blaming either of you two gentlemen, I'm just reacting to what we were told as a city council. And I can tell you that I tested that and looked at it just this weekend about a missed pickup, and it was absolutely closed. The case number was closed the day after it was filed, and the garbage got picked up 2 days later.
Mr. Chairman, that in fact may be accurate, but what I'm saying is that shouldn't be our internal process. So
I agree. That's why I want to keep bringing it up, because we keep complaining, but I don't see anything changing.
because GFL they go direct to him, they might be closing it as soon as they get it and going out and picking it up. That's what we got to find out is are we closing it or is GFL?
Yeah, and firsthand, in the last 72 hours, something got closed, a whole street was missed, any complaint filed on that street got closed. A Friday pickup got picked up today, the cases were closed yesterday. That's wrong.
All right, I got,
And I'm gonna guess, if any of those residents didn't file a second complaint, you're not gonna know to zap them with $100. And it's an entire street.
Mr. Chairman, we'll have to verify. I don't believe that contractually, I believe the requirement is just how you mapped out. If we're closing it or if they're closing it internally, I believe they're cutting a step out that they should not be
The
cutting.
second thing that I proposed was, we shouldn't, and I don't believe the contract requires us to get an individual complaint from every house that was missed. Again, from my firsthand experience and several people on council, we know that full streets are getting missed. We know only a fraction of those residents are filing a complaint, but if I fill one out and said my whole street got missed, GFL gets that information. Whether we got 1 complaint or 20 complaints, we should hit GFL for every house that got missed. The contract just says they